We do too. Great. Welcome. Nice to have you here. Hope you enjoy it. Hope you will come back for other topics. So for those that don't know me, I'm StephanieParson. I'm a full-time real estate broker. And so today I have a couple of my teammates, Sharon Brunner back there at the table, and then Kim back running the camera today and helping out. So our team has over 50 years of experience in real estate, and we specialize in working with seniors. We also provide downsizing assistance for those needing extra help to make a move. And the Senior Empowerment True Series was born because we saw firsthand how seniors needed helpful guidance and resources for later in life decisions and moving. So a couple housekeeping things real quick. We run from 10 to 11 with our presentation, sometimes 11:15. Then we open it up for questions at that point in time. So we do ask that you hold your questions until we finish so we can kind of get through what we hope to get through today. Also, we have a no selling policy, but information is available to pick up at the end of the seminar, should you desire, or if you want to talk directly to any of our panelists. And our next month's seminar is the truth about maximizing your taxpayer benefits. We're going to have Kurt Barr from the St. Charles County Elections Board here, the director of the Gateway YMCA, and then also a marketing director from the St. Charles City County Library to talk about maybe ease of voting, to talk about volunteer opportunities with voting, also all kinds of free stuff that you may not know that's available to you in the area via your taxes that you're paying. So today's topic, so I won't need Medicaid and I don't qualify for VA benefits, do I? I think the VA thing's pretty clear, but sometimes there, as we're going to get into, you're going to find out, you know, you not necessarily have to be a veteran. Maybe you're a surviving spouse of a veteran. So also, it's always great to have this information to pass along to friends and family. So please invite others to come in the future as well. All right, so life circumstances can change, even though we do plan. Long-term care costs are very, very expensive, and it's good, I mean, things change, and it's good to know about potentially what some of the other resources might be if you find that you want to take advantage of them or that you need to take advantage of them. So we have a couple expert panelists here today. So Rudy and Amy, you want to come up front, and so let's give them an open round of applause. So, volunteering their time here with us today. We very, very much appreciate it. So you will need to turn your microphones on. I think they're off. So guys, tell us a little bit about yourself and your background and why you're here today.
Let me go first, Rudy. You're cool for going first. All right. So my name's Amy. I am an elder law and estate planning attorney here in St. Charles, and I actually kind of worked my way into this position backwards. I started out as an intern at an elder law and estate planning firm, happened to be Rudy's firm, about 19 years ago. And I loved the area of law. I was a paralegal for many, many years, but about 8 years ago, I was like, I'm bored. I can't advance in this position. And from my knowledge and helping people in this area of law, I decided to go to law school. So I did that, and then about a little over a year ago, decided, now I'm going to start my own practice. So the last year has been crazy and wild, but an amazing year of being able to help people in grow business.
Thank you, Amy. Can you guys hear her okay?
Yes.
Okay.
Yeah, well, I can't tell you what a pleasure it is to be up here and share this with her because I know how good she is.
Thank you.
I'm Rudy Beck. I started my law practice after I got out of the Army in December of 1974. This is my 50th year. And about 23 years ago, I in addition to doing estate planning, I added elder law. And specifically with regard to elder law, I added Medicaid benefits planning and then VA benefits. So all we do in our firm is estate planning in those two areas of elder law. That sounds simple, doesn't it? It ain't. So we're here to talk to you about this, and Amy and I talked about this ahead of time, and we're perfectly happy to keep this like an open discussion forum. So as we say things, hold up your hand. If you got a question, it's probably somebody else's mind as well, right?
Yeah. So Rudy, we do ask them to write down their questions.
Oh, okay. You want to
And
wait until
we'll-
it's over. Okay.
And
Okay.
then we will have open Q&A, okay? So first slide up here, I apologize guys, this is my first time like doing multi-purpose things up here, so you'll have to bear with me. So first I wanted to start off with a little bit of an overview. So what is elder law? I found this definition, hope you guys agree with it. Elder law is a legal practice that focuses on the legal needs of older people and those who care for them, including family, friends, and caretakers. Pretty good synopsis there? Okay. So, backwards. Hold on, bear with me. All right, so that's elder law. And I noticed both of you in your firm names, you say elder law and estate planning or vice versa. So what falls under the elder law umbrella? I know estate planning is apparently one of them.
Yes.
All of the above, really, in
Yeah.
one way or another.
Sure. So I did this and didn't really let them know I was throwing this stuff in, so that's
Yes, you did.
what are we come up here? So these, I just thought it was important because I don't know that everybody knows what actually falls in that. So elder law is the big umbrella, and estate planning is one of the things under the umbrella. Would that be kind of a correct statement?
I think so.
Okay, all right. And then we have all different categories here. Healthcare, public benefits, which is a lot of what we're talking today. Housing, family law, tax law, disability. Okay, and estate planning. What exactly is estate planning? That's kind of like a big balloon. This is something clean and simple.
That's accurate.
Okay, process by which an individual or family arranges the transfer of assets in anticipation of death.
Stephanie, I think one thing to keep in mind, because I was an estate planner long before I started looking into elder law, and I thought I had a really great durable power of attorney for financial matters until I got into the elder law side of the business, and then I realized, oh boy, I was leaving some very important things out of the durable power of attorney for financial matters.
Okay. And you found that out when?
About 23 years ago, once I started really focusing, or not focusing, but educating myself in the area of elder law, and I realized, oh, wait a minute, I need to include gifting provisions in my power of attorney document, gifting to a trust that maybe I don't even create myself, as long as that trust has a plan of distribution which is the same as my existing plan of distribution in either a will or an existing trust, because I don't want my agents to start giving things away to themselves. But so there were many different things that, and unlimited gifting, by the way, not just limited to the annual exclusion amount, which today is $18,000 per year. So
Was that about the time that you were saying that you found that maybe it wasn't exactly the best power of
Well,
attorney?
what I'm saying to you is, if somebody only does estate planning, they're probably not having a complete enough financial power of attorney document. We have found, I'm sure you found that to be the case too.
Okay, so I think, I'll just say it, you guys specialize in this, okay? There are attorneys that do divorce, that do estate planning, that do traffic tickets, that do all kinds of things. So they don't necessarily specialize in this, so maybe they're not going to know everything and be as detailed as someone that would specialize in it.
Absolutely. And if I can add to what the slide said
Yeah.
about transferring assets at death, and Rudy hit the nail on it with power of attorney documents, it's not always just planning for what happens when I pass away. That's our goal. We want to make a smooth transition. We want
What's
to
our
get
goal?
everything
To pass away?
Well, our goal for I'm sorry. Our goal is for the estate planning is to transfer assets at death.
Yeah.
None of us want to pass away. But power of attorney documents during lifetime are planning for, estate planning can be planning for incapacity, because if you don't have a power of attorney document, you can't make your own financial or healthcare decisions. We have to get court-appointed conservator guardianships, and those are timely, difficult,
And costly.
Yes. So those power of attorney documents, and just like Rudy said, we're always looking for specific language, and I often have clients in my office that are like 40 and 50, and I'm explaining to them that I'm putting all this language in, and I'm like, it's for Medicaid down the road. I know you're too young to talk about it, but it's on our radar. We don't want to wish in 10 or 15 years we did.
And it's like, and another thing too, in the area of estate planning, don't let anybody ever tell you that you don't have to worry about probate if all you have is a will. You don't have to worry about it, you're dead. But your surviving family members will not appreciate very much if all you have is a will to handle who gets what after you die. Because a will in that situation is a one-way ticket to probate court. You want to know who wins when you go to probate court?
Attorney?
You're looking at us, we win. Not the court. No, the court costs are very minimal. But the attorneys win. And it's a time-consuming process, by the way.
So I deal in working with seniors and families on selling real estate. Unfortunately, a lot of times it can be that it is where someone has recently passed. And, you know, I always ask, you know, who has ownership, and dig into that. And no, there's not a beneficiary's deed. No, there's not a trust. We think there's a will. Can't we just sell it now? No, sorry. There's a process you have to go through. Okay, what's the process? Well, you're going to have to go through probate. You need to hire a probate attorney, and there is some costs involved in that. So I don't like having to tell people that, but basically that's just when you don't plan and do things properly. So what are typical goals of having an estate plan? So it providing for loved ones, mitigating or avoiding probate, right? Minimizing taxes, providing for the orderly distribution and stewardship of assets, protecting assets, planning for incapacity.
Perfect.
Thank you.
It's all of it.
That might have been one of your guys' slides, actually, so.
Maybe.
Okay. These are, you guys already kind of mentioned these. These are common tools used in estate planning. Wills trust,
Yes.
living wills, power of attorney. And there's a note at the bottom, Rudy, if you want to read that to reiterate your point.
Everyone can benefit from having a will, no matter how small their estate or simple their wishes. Yeah, a will is better than nothing at all. A will is better than TOD or PO, transfer on death, or pay on death, because you never know what condition somebody's going to be in if they survive you. But a will requires probate, whereas a living trust will avoid probate. So we always encourage people, let's make sure everything funnels through the trust. And the benefit to be gained for the family and the cost to do the trust along with the will and durable power of attorney for healthcare and financial matters, the benefits far outweigh that upfront cost. I can't begin to tell you how many times we have seen families come in, oh, thank you for setting it up. It made it so easy for us to transfer because we don't have to wait with the living trust. We can go ahead and get things done. We might tell them reserve some money to pay unexpected bills that might come in 6 months to a year later. But you can still dispose of, depending on how much, 90 to 95% of everything through a partial distribution. But you're not waiting on a mandatory 6-month waiting period according to the probate code. So, yeah, those are ahead of me.
And as much as we sit up here and started our conversation about we don't like wills, we still do them.
Oh, yeah.
And We do them as what are called pour-over wills with our revocable trust most of the time when we're doing trust, and I always tell my clients, that's a safety net provision. If you forgot about an asset, I opened a bank account when I was 15 and moved away, and my dad called me like 10 years ago and said, Amy, the credit union called me about this bank account. If I would have passed away, that would have been a probate asset because I forgot about it. Pour-over will would have dumped it into the trust. The other benefit of a will is for individuals who have minor children. If they have no surviving parents, the only way to designate guardians of those minor children, and it be your choice before you pass away who those guardians are, is through that last will and testament. So we use them, but we have much other preferred methods.
So when we talked on the phone, you guys were very clear about if there's one thing that you absolutely have to do.
Power of attorney document.
Yeah.
Oh, yes, absolutely.
That's what I said. I tell everyone, as soon as you're 18, sign a power of attorney document. I can't wait till my daughter turns 18 next month and I make her sign that.
Yeah, that's great. Oh my gosh.
Yeah.
Okay, and a couple things, they can be immediate or springy.
Yes.
So like a trigger event or something.
Yes. So an immediate power of attorney means it's effective the day that you sign it. Whoever you appointed as your agent or agents do not have to have doctor's letters of incapacity to act on your behalf. That scares a lot of clients, and I say it's really just a permission slip. Most of the time, actually all the time, we should appoint the individual we're appointing as a power of attorney. So if you don't trust them, we need to be having another conversation. The springing power of attorney says this thing doesn't spring into effect until one or two doctors you get to choose in your document declare you incapacitated. I think Marie and I might have different opinions on this because you do springing, don't you, or do you do immediate now?
Rarely do we do a spring.
Okay.
And I always tell people, do you trust the person you're going to name?
Yeah.
They go, oh yeah. Well, how much do you trust them? And it's a legitimate question to ask because we had one client's older daughter who managed to take $186,000 out of his two different investment accounts in about a year and a half because she was a 7-diamond member at Harrah's Casino. Fortunately, there was enough left in those investment accounts to take care of the other 4 children of a like amount or even greater, and of course he excluded her from anything else. But he was a World War II Marine vet. And he sat there and tears were silently going down his cheek, thinking it was heartbroken that his oldest daughter would do that. I said, look, she's an addict. Just happens to be gambling is her addiction.
And I hope that's something that you guys, when you consult with clients, that's a conversation that you're having with them about talking about people you trust. And that there are, I guess, sometimes there's a lot of unfortunate financial problems and drugs out there. There's just issues that you don't want to put a person in that power position to have those issues.
Absolutely, yeah. When I'm meeting with my clients and we're talking about agents and who's in charge, I ask about background, relationships, just so that we know, well, is this person capable, can we trust them? And then sometimes people don't want to tell you their personal family information, so it's kind of our job to dig in a little bit more and make sure that the people were appropriate. It's the client's choice at the end of the day, but we're helping to guide them to make that better choice.
We have to. And I always, a lot of times I will ask permission to get very nosy because I want to be able to ask questions that nobody might expect. Do you have a son or a daughter that has an addiction problem that you know about? Do you have a son or a daughter that cannot even handle $1 if you give it to them because they're going to go out and spend $2 before that dollar very hits their wallet? I want to know. Why do I want to know? I want to make sure they don't make a mistake. And so we have to ask the client to allow us to get very, very personal. And the good news is, I'm sure you can tell your own version of this, but when I walk out that office door, I'm the dumbest guy on the planet. I don't remember anything that I talked to a client about. Confidentiality. It is the greatest privilege that we as lawyers are given. We maintain client confidence. So another family member might ask us, or a child may say, hey, what did mom and dad? I don't know. unless mom and dad had given me permission to talk about it with somebody else, I'm dumb, I just simply don't know.
Well, that's an important thing to know about in working with an attorney, is that they have a duty for confidentiality. Absolutely. So asset protection planning, we're almost to our topic here. So process of arranging one's financial affairs to prevent or significantly reduce risk by protecting assets from creditor claims, or protect assets from being finished, I guess, or got finished in there. That was a strange word.
Yeah.
Sucked up,
Yes.
utilized by long-term care costs. And that's really the topic that we're trying to get to today. I'm going to click the woodwork here. All right, so let's talk about, Amy, let's talk about Medicaid.
Sure.
Okay, so its long-term care costs are very, very expensive. And I don't know, does anybody know how long they're going to live? I don't think any of us know that. And, you know, a lot of times I hear people and talking about selling their homes. I'm never going to move. They're going to carry me out in a pine box. And that's kind of hopeful, wishful thinking. Unfortunately, it doesn't usually happen that way. At least that's my perspective and what I experience. So talk about Medicaid and how they can assist with all of these different types of care levels to help preserve their assets.
So I think one of the biggest misconceptions in our community is, I made too much money to apply for Medicaid. That is a very, very common phone call to my office. And most Medicaid benefits, if they have an income cap, it actually depends on what your medical expenses are. So, and there's also not a one-size-fits-all Medicaid benefit. There's multiple types of Medicaid benefits. Our most commonly known one in the community is probably nursing home Medicaid. That's for individuals that need 24-hour care in a skilled nursing facility. Private pay rate of those facilities is about $7,500 to $10,000 a month on average. There's Medicaid benefits that you can apply for to help cover the majority of the cost of that. There's some rules where you get to pay some or all of your income, the majority of your income. That's our most commonly known Medicaid benefit. There's also a Medicaid benefit for individuals that are in assisted living communities or in skilled nursing facilities and not receiving those nursing home Medicaid benefits. It's not a huge amount of money. I refer to it as a pension because it's just like a pension benefit. It's a monthly stipend that drops into your bank account. It can be anywhere from $342 to $440.
So it's just a supplement.
It's a supplement, yeah, just a little cash grant it's called. And depending on what your income is, you could also qualify for kind of dual eligibility or extra help where Medicaid pays your Medicare premium. So now you're getting another $174.70 per month based on this year's Medicare premium to have extra cash in your pocket to pay for that assisted living community or stretch out your money to make it last longer. Another Medicaid benefit a lot of people don't know about is home and community-based services. It's a Medicaid home care benefit where Medicaid will pay a private duty nursing company for up to 42 hours of home care per week for you, no cost to you. That means you get to keep collecting all your income and Medicaid's paying for that home care. There's also spend down, which is for individuals who live in the community, may not need any care yet, but they have limited assets and limited income, but they may have monthly medical expenses that kind of go up and down. On those high months, Medicaid can pick up the kind of the amount over whatever your spend down number is, and everyone's spend down number is different because it's based on what your income is. And then our most recent Medicaid benefit that was just put into effect in July of 2021 is called the AEG, and that's Adult Expansion Group Medicaid. And that was Missouri's way of finding, kind of closing in the gap to give Medicaid benefits to individuals who are between the ages of 19 and 64 who have high medical expenses and don't have income or have limited income. There's actually no asset test for that Medicaid benefit. That's the one and only Medicaid benefit there's no asset test for. It doesn't, a lot of people don't become eligible for it because a lot of people between 19 and 64 who are really ill may already be deemed disabled by Social Security, and that kicks them out of eligibility. But it's helping those people who may get a terminal illness and all of a sudden we have a parent or a single family member that can't work and they have no income or very limited income to help pay for those medical expenses. Am I missing any?
The difference between individual and married.
Yes, on eligibility requirements, so huge. A single individual, doesn't matter any of those Medicaid benefits except AEG, the newest one. You have an asset limit of $5,909. For married individuals, it depends. You can have a minimum of $11,818, or you can get to keep up to $154,140. And the jumping off point for that all depends on where your assets start at. And the other difficult component of that is that range of assets that you get to keep only counts for home and community-based services and nursing home Medicaid. For that supplemental nursing care benefit, a married couple has to be at that $11,000 threshold. So it really depends on where you are, level of care, to determine how do we get you eligible. And one of the things we talk about is how to get you eligible if you're over those numbers.
And I would add to that, don't let anybody tell you, oh, you've got $300,000 or $400,000 in lifetime savings, you're married, and now you've got a spouse that's going, oh, you won't qualify for Medicaid. Bull. We have helped people with a lot more money qualify for Medicaid because Congress, probably at the urging of a great insurance industry lobbyist, decided, okay, you can put the money that you've got over and above what you're allowed to keep under the law, you can put that into what we call a Medicaid qualifying annuity. And the spouse who lives at home gets the monthly payments. And those annuities can, shortest that I would ever recommend is 2 years, but generally it's more like 5. And the surviving spouse gets the money on a monthly basis and then reinvests it. And oftentimes, if the surviving spouse is still fairly healthy, we'll go into what I call phase 2 and have the surviving spouse start putting that money into an irrevocable trust for investments. And if there's a house, maybe we put the house into what Amy would call a residence protection trust.
So you started off with a lot of numbers.
Yeah, we have.
Oh my gosh. So I'm going to throw out an example, a real example of I've talked about my parents frequently in these. So my parents are now, 80, 83 and 84. They actually did go in and do all of the trust, estate planning, asset protection. My dad being just a year older, but men typically pass before women. So they weren't indigent. They never had used, government programs, never needed to. They had retirement money. They owned their home. However, my dad was diabetic for many years, and he also then had a stroke and had some frontal temporal damage. And so he needed a little bit more. My mom was the one that was more healthier physically and mentally. My mom had a long-term care policy. Okay, my dad did not. It wasn't affordable. So they went in and not knowing what exactly would happen, they went in and did the process, and they got it set up so that my dad would be in a position to qualify for Medicaid if it was needed, okay? And it did come to that. So he went into skilled nursing on the Medicaid program, okay? My mom remained in the home. Eventually, not too long after, then she needed to also have more care. We're utilizing her long-term care policy. They're in the same community. They get the same care. You never know who is on Medicaid and who is not. So I just wanted to point that out to people. It is not like you're not going to get the same kind of care just because you're using a Medicaid benefit.
There's not a Medicaid wing in a nursing home. And in fact, the staff supposedly is not told who is on Medicaid or who isn't. I will tell you that in most cases, a Medicaid recipient is in a shared room. Although the law does now permit
some assets, so there will be some inheritance money there. And so I just want to give you an idea, if you guys haven't been through this before, you know, a realistic case of how it can work, and that it's a benefit, it's not a bad thing, it's out there for people to take advantage of. It's very, very expensive long-term care.
Stephanie, we want to put people in the position of having the option of going the Medicaid route or not.
Yep.
So I tell people, I said, how many of you out there remember Ozzie Smith, right? For the Cardinals. Well, a great shortstop is always in a position to go after the ball no matter which way it's hit. We want to put a family in that position. Which way is the ball going to be hit when you have a parent in need? Well, we've got planning in place that will allow you to go whatever direction is in your best interest. And perhaps we'll get to this, but one of the first questions I would ask in your mom and dad situation, was anybody in the military service?
Well, that's a great question.
Mm-hmm.
And
It's a
to
segue,
answer
isn't it?
that, okay, because this is one of the things that I learned, to clarify, is that, you know, my dad was in the reserves, so he didn't actually have to serve because he had a child. He went into the reserves, so he never went, you know, necessarily active duty. So the answer is no there, correct?
Under that circumstance, yes, the answer would be no. There would be no benefits available to help pay for long-term care.
Yeah. Yeah.
That's exactly right.
Okay. So, moving on more about Medicaid. Oh, gosh. So we talked about, we talked about it all. How about look-back periods, division of assets? Those are terms that are thrown out all the time. So maybe you can...
So I'm going to go division of assets first because it ties in more with mom and dad's situation and how that works. So generally, husbands and wives will go to a nursing home, and the nursing home will say, if you want Medicaid, the first thing you have to do is a division of assets. And people are like, what is that? And no one knows the answer to it. So I get a phone call, and the question is how do I divide our assets? Well, it depends. The way that we do, the way division of assets is triggered is that if either spouse, doesn't matter if it's the one now in the skilled nursing facility, or if the spouse, and I'm going to use my wife as my community spouse, the one out in the nursing home, just because traditionally we have husbands in the nursing home more often. So even if my wife had a rehab stay from a hip replacement 6 years ago and she was in the hospital, rehab facility, or skilled nursing facility for 30 or more days, that triggers our division of assets. So then the next question is again, what's the division of assets? Whatever amount of countable assets you had at that time period, we either divide in half, or we have to spend your assets down to the maximum allowable amount for Medicaid, which is that $154,000. So we'll do both ways. If I've got someone that has $100,000, or had $100,000 6 years ago at the time of that division, but now they're down to 80, they've actually already spent 20. We have to cut in half and spend them down to 50. So then they're like, how do I spend $30,000 and get my spouse on Medicaid without just writing a check to the nursing home? Lots of strategies there. My first question to most people is, do you have final arrangements made? We all know that that's going to be an expense at some point. It can be a very small expense or a really expensive expense, but let's prepay that, because if you make those irrevocable plans, you've now taken some cash and turned it into an exempt asset for Medicaid purposes.
So that's one way to spend money down and use it for something that unfortunately we know is inevitable.
Exactly. And another big misconception about the spend down is they think because you're spending down half of the spouse's assets that's in the facility that we can only use that money for that spouse in the nursing home. No, we can do both the husband and wife's funeral plans. If the wife says, my AC is about to go out any day, it's going to be $13,000, it's a perfect way to put money towards the spend down. I tell people, don't go spend money just to spend it, but let's find good ways to spend it. If spouses still have a mortgage on a property or debt somewhere, we'll look at spending that down, but we don't always spend all the debt, and that's what I'm going to talk about, how nursing home payments work in a spousal situation too. but paying down some debt's a good way. Is the spouse still driving? Does she have a car? Is the car falling apart? Was she anticipating maybe purchasing a new car? That's a good way to spend that money.
Yep. So, can I interrupt for a
Sure.
second? So going back to my parents, okay, when my dad did go into skilled nursing, and she was handling all of this, and for transparency, it was an elder attorney. Neither one of these people here were the elder attorney, but they can comment on this to see if this is right or wrong, or if you have an opinion on it. So, as I recall, he went in, and then my mom had some money she had to spend. So she went and prepaid funeral expenses.
Good.
And then she didn't owe anything on her home, and she didn't owe anything on the car. But there were some things that probably made sense to change out in the home that would eventually be inherited or need to be sold. So she got some work done. She got the place painted, she got new flooring, and so I'm assuming that was the spend down.
Absolutely.
Absolutely.
Yep, a good way to spend it, because if mom still was gonna live in the home, we want her to
She
be
did.
comfortable, and it's appreciating the value for when it's sold in the future, or if it's inherited.
We got more money for
Yeah,
it.
that's absolutely, I asked, do you need any home improvements? Are there things that you've been kicking the can down the road on that you're like, we need to do this and we haven't? Now's the time to do it. If you're like, I might end up needing to do this next month. The importance of that spend down is that the month that you complete the spend down, even if it's August 31st, that spouse's Medicaid eligibility is retroactive to the first day of that month, as long as they were also in a Medicaid bed the first day of that month. They didn't go into a Medicaid bed till the 15th. The eligibility can't be retroactive until the 15th. But when we're doing this kind of quick, not always quick, but a lot of the times we're trying to do it quick to alleviate private pay months at the nursing home, a lot of those things can be done or purchased pretty quickly. On the home improvements, I always have the asterisk of, if you trust the contractor, it's okay to pay them to get it done, even if they start. Sometimes you're paying half and then you're not paying the other half till it's done. And that could put us into another month or anything like that. But these are all things that we talk about when we're strategizing. What's the best way to complete this spend down? And then, so for that sort of 30 to 50,000, we can do that pretty quick with a lot of things like that. Rudy's mention of the Medicaid qualifying annuity. So our next example is, I've got someone that comes in, he's got $600,000 of assets. He's already been paying a facility for a private pay room for his wife. It costs $11,000 a month. He says, she's doing well, but she can't come home. So she's probably gonna be here for a really long time. The first time I met with him, he said, this doesn't feel right to me. My dad wouldn't approve of this, and a lot of people still do think, I mean, he's a 70-year-old man, is still like, what would my parents think about this? And I tell him, think about it, call me back if you want to. If not, no big deal. However, 3 weeks later, he called me, and I think he had written another $11,000 check to the nursing home, and he said, what can we do? And that's where we utilize that Medicaid qualifying annuity. So this individual, $600,000, his maximum amount that he gets to keep is $154,000. So we don't have that ability of cutting in half like we do for the kind of the lower asset threshold. So anyone over double of $154,000, so $308,000, has to spend down to $154,000. It doesn't matter if you have $350,000, $650,000. So our $600,000 example, we went through all the same questions: funeral plans, home improvements, car, any of those expenses. Let's get them knocked out, and then tell me how much how much have you spent on that? He spent about $50,000. So now instead of spending $450,000, we needed to spend $400,000. How do you spend $400,000? And that's where we do the Medicaid qualifying annuity. The moment it's purchased, the money's out of the bank account. Medicaid eligibility is retroactive. His first appointment with me was like in February. Our Medicaid annuity was done by March 23rd.
How much can you put in the Medicaid annuity?
There's no limit.
There is no limit, but I've often followed the philosophy that, pig get fed and hogs get slaughtered.
Yes.
So we had a client that had over $1 million. We said, you know what? We're not going to do this. Well, why not? We can do it, can't we? I said, yeah, legally we can, but you can afford to private pay for a while. if we start throwing Medicaid qualifying annuities out there for people who have your kind of wealth or more, I said we might see a very adverse reaction by the agency that controls the Medicaid here in the state of Missouri, the Department of Social Services, and they might go to the select congressman or state senator that they know and say, we need to change the law. People are taking unfair advantage of the Medicaid qualifying annuity. We don't want to raise that specter, or we don't want to call attention to somebody who's got a great deal of wealth.
Right.
Does that happen very often? No, it does not. And I would also
So is it your position that, well, it's legal, but maybe it's not
Always appropriate.
It's not always, it's not advisable.
Okay.
Always advisable.
Yeah.
And we're saying that not because it's illegal at all for the family. We can do it for the family, but the overall impact to the system could be very adverse.
And does it make sense, is always my question too. I'm not a financial advisor, I'm not a CPA. However, being in this area of law, we have to be aware of ramifications financially, tax-wise. If I have someone that has $1.4 million, I'm like, how much are you earning on this? You might be earning enough from that investment that you don't need Medicaid because you're not dipping into the principal of that. And sometimes if some of that large chunk of money is IRA money, if we convert it into a Medicaid annuity, sometimes it's taxable. There's a murky rule if you take the money out and put it back in within a year or within 60 days. If you do annual payments, you can do that every year. I've also heard that could be questioned. So I really err on the conservative side of this planning, and that I don't want to put anybody in a worse situation than when they came and saw me, especially if the planning may not make sense because of tax or just financial impact reasons. And the other kind of component of that Medicaid annuity too is that it has certain beneficiary requirements that have to be set up in order for Medicaid to say it's approved. And one of those is when wife in the community buys that annuity, she has to name her spouse as the primary beneficiary. So if she passes away before it's fully paid out, and like Rudy said, most of them are 5 years, that spouse in the communities or in the skilled nursing facility is getting those payments. So it's a risk that way, in that there's a chance these funds could go to our nursing home spouse. Very unlikely, I've seen that a handful of times, but it's possible because no one knows what tomorrow holds. The second beneficiary designation is Medicaid can get a crack at it only if it's not fully paid out and that both spouses pass away within that term of the annuity, which again, most of the time is 5 years. So when we're doing huge dollar amounts or looking at huge dollar amounts, that's another consideration.
That's a risk.
Absolutely.
Yeah.
And people are like, well, I don't want Medicaid to get any of the money. Absolutely, we don't want that to happen. One of the benefits or ways to think about those Medicaid annuities when we're weighing our pros and cons is Medicaid's actually paying a lower rate than when someone goes into the nursing home at the private pay rate. It's just like our insurance. If we've got supplemental insurance, our doctor's getting paid less than if we walked into the doctor's office with no insurance. Medicaid works the exact same way. So if someone does end up with a Medicaid lien because individuals pass away, the Medicaid lien amount is actually going to be less than your private pay amount if you would have private paid. And then people are like, well, what if I pass away at year 1? Well, that's not that huge of a deal either, because Medicaid would only have paid for that first year. They can't take it all. They can only take up to the amount of Medicaid benefits that they paid out. So I don't
So like a reimbursement.
Yeah, I don't want to get too far in the weeds on how they work, but they have compliance things. So that's also when we're talking about those annuities kind of situation. And then I've probably almost put you to sleep with divisions of assets, but if you want to talk more about
No, I just also want to mention that, well, I've got an IRA with $400,000 in it, and I'm going into the nursing home, so it's going to have to be spent, right? No. There are a couple of insurance companies in the United States that will allow the annuity to be purchased with the IRA money, but name the spouse in the community as the monthly beneficiary. And Missouri follows what is called the name on the check rule. If the one who lives in the community, if his or her name is on the check, the state of Missouri says, that's okay. We won't count it. So you've shifted the IRA benefit to the spouse who remains at home, and you've kept the IRA money safe. The trade-off is how soon are you going to have that annuity pay out for the benefit of the surviving spouse? Because nobody wants to take $400,000 and $80,000 a year over 5 years if they can keep from it. That's the trade-off you have to be thinking, because if that spouse were to die in the first couple of years, there's going to be at least, in all likelihood, $100,000 to $120,000 chunk that gets paid out, because that's the extent of the Medicaid benefit that had already been paid for the spouse in the nursing home. So you got to keep this stuff in mind, and I think one thing becomes apparent. One size does not fit all. Do not, under any circumstances, well, so-and-so said, I don't know what they're talking about. Amy and I live in this world. We work in it every day. And she said to begin with, there is more, I call it myth and misconception, based on what people have heard about, or even what well-meaning financial advisors in some case will tell you, simply because they don't know the whole arena or realm of what we know.
It's hard to be, there's a lot of generalists out there. And so it's hard to know everything, all details about everything. That's why you go see a specialist. When you need a knee replacement, you go to the best knee replacement doctor, not the best maybe shoulder replacement doctor.
Stephanie, in my first 10 years of practice, I handled how many DWIs, I handled how many divorces, regular traffic tickets, but mainly divorces and I wouldn't, in some criminal cases. There's no way I would touch any of that today. It would be malpractice for me to try and do it, because I don't know enough. Just simply don't know enough.
So we have a slide up here, Medicaid and division of assets, separate countable assets versus non-countable.
Yes.
Is that, okay, so yeah, if you guys would look at this and tell me if it's correct or not.
I'd like to stay home today.
So
it is. So it is always one vehicle, and you can request a second vehicle be exempt. Most Medicaid, sorry, go ahead.
Yeah, no, I mean, this list is very surprisable to me.
Yes.
Okay, because, your primary residence, that's where most people's biggest asset is.
Yes.
And you don't have to count that.
That's right. That's an exempt asset. For a married couple, it's an exempt asset as long as that community spouse, the one who's not in the nursing home, outlives the spouse that's on Medicaid. It forever bars Medicaid from placing a lien on that house. Now, if we have a single individual or the community spouse that passes away and leaves the spouse living in the nursing home, that's exempt for the entire time that that home is there, but Medicaid can put a lien on it up to the amount of Medicaid benefits that have been paid out on that Medicaid recipient's behalf. Or if it's sold and the title company does a title search, they'll likely see the lien. Some title companies are being really proactive and calling this, sending a MoHealth net release, which I don't really like, but they are sending in a MoHealth net release, which is a release that we use for probate estates to make sure there's no Medicaid lien. Even if even after their title search, there's no lien of record yet. The title, some are sending in that MoHealth net release on their own and seeing if there would be a claim, which there's been a lot of pushback on that. We've had a couple of clients, like if Medicaid hasn't placed a lien and we're not in probate. But essentially the home is exempt, but potentially subject to a lien at some point, or Medicaid clawing back at the
Which is why I mentioned phase 2, because we would then cause the family home to be put into the name of the spouse who still lives there. And hopefully he or she would agree to have us immediately place that home into what we call a residence protection trust. It's an irrevocable trust. But since we're not giving it away prior to Medicaid qualification for the spouse who's in the nursing home, she can give it away. And if she survives for 5 years after that transfer is made, that home is free and clear forever. And if the trust will be worded in such a way that at her, let's just say her subsequent death, the children would take the home at a new basis equal to its fair market value at her date of death. And if it's sold while she's alive, we still get the capital gain exclusion up to the first $250,000 of gain over and above what was paid for it to begin with. So there's a lot of reasons why seeing somebody like me will serve a family's needs much more so than going to someone who does not profess to be an elder law attorney. And Amy and I have seen this a lot. Oh yeah, I can do that trust for you. Oh yeah, I can do this. No. No.
There's too much at risk.
It's way too much of a risk, and fortunately, she's one of the best. And so there are a few of us who do this regularly and who are well versed in it. There are some who aren't. And so you have to ask around. And one of the reasons why Amy and I are both here, I'll speak for you for just a minute, but we want you to know. You don't know what you don't know, but when you start to find out about it, then you can say, if you hear somebody else, you go, oh, no, that's not quite right. And maybe you can help a friend of yours who has heard it wrong get directed to someone who can. You got a house, give it away. Doesn't matter, VA doesn't care because they consider that exempt. Car's exempt. Go ahead.
But don't give it away without talking to an attorney, because you
Well,
can create bad tax ramifications.
Because it can be disastrous if it's not given away properly. It can be disastrous if not given away properly. There again, we want to make sure that we preserve the right to receive a step-up in basis at the time of death. If you just give it away, by the way, okay, let's talk about that a minute. So, I was told I should just give my house to my kids. And after 5 years, I'll qualify for Medicaid. How much is your house worth? $350,000. What'd you pay for it? $52,000. Well, guess what? When you gave that house to your children, were you told that your children assume the same cost basis that you have in it? What do you mean? Well, if they go to sell it, they're going to pay a capital gain tax on $300,000 of gain if they sell it for $352,000. Well, nobody told me that. Well, it's true. So maybe you want to give it away. That's okay, but giving it into a trust is the best approach. But if you don't want to deal with that, we go back and file a correcting deed to say you're retaining a lifetime right to live there and use and enjoy it. Because that retention of what we call a life estate interest causes under the Internal Revenue Code, the children can now take it at a new basis equal to fair market value of death.
Awesome.
Oh, it's a big deal.
Yeah. That is
But again,
especially with the values
Oh,
in our
my God.
area, just on a
I bought a villa unit in 2010 for $245,000. Sold it in 2014 for $265,000. The people I sold it to sold it 3 weeks ago for $395,000. Come on, really? It's crazy.
It's true.
It's crazy out there.
Yeah.
So, with regard to non-service connected monthly or pension benefits, they call it a pension benefit because it's really what it is. If you qualify for the base pension, well, what do you have to do? Well, you have to have been on active duty for 90 or more days during a period of war. Well, what are the periods of war? In the handout that you're going to be able to get in the back when you leave, you'll see those periods of war. I've only had, I think, 5 either World War II veterans and or surviving spouses of World War II veterans in my practice over all these years. Only 5, I think, 5 or 6. Most of the time it's South Korea or Vietnam. And tragically, some of the Gulf War guys, they were exposed to chemicals, and we're seeing that now too. But there we talk about service-connected compensation benefits. There are asset limits. The VA, you may have heard of the 5-year look back with regard to Medicaid. The VA has a 3-year look back. They don't want you giving anything away and then immediately going in the next day and asking for the benefit. I won't get into an explanation of how all of that is determined because we run it through a formula that we developed at our office. Amy's got the same one, and we can tell you, how's this gonna look if you need a benefit 2 years from now? Well, here's how it's gonna look. You won't apply. You'll privately pay for that year, and then maybe you get the VA benefit. So I would say to you, if there's a question at all about whether or not you could qualify for a VA benefit of either type, come see us, come see Amy, or someone else that you know in the community is well versed in this part of the elder law practice. It is too important not to take the time. And by the way, if they say, well, it's going to cost you $250 or $350 if you come in and see us, and we'll credit that against you, against our fee if you hire us, go see somebody else. I mean that, go see somebody else. And I say that very frankly because there are enough of us in this area that won't charge up front just to find out how we can help, that take advantage of that.
Yeah, good point. So, Rick, can you, or both of you, either of you, can you talk more about the surviving spouse's benefits?
Sure. Amy, you want to go ahead and jump in?
So the most common is surviving spouse, the pension with aid and attendance, and that has the same eligibility requirements for the veteran. Her deceased spouse had to have at least 90 days of active duty, with at least one of those being during a period of war. She still has that asset limit, which is $155,356. But if she has medical expenses that are close to meeting or exceeding her income, she can qualify for $1,478 per month. Now, a lot of people don't realize with that $155,000 asset limit, if you give away assets under that limit, the VA also doesn't penalize you. That's different than Medicaid, which we didn't talk about lookbacks, and we can quickly too after this. But for Medicaid lookbacks and gifting with VA benefits, you could potentially not be subject to a penalty. But the biggest component of that that surviving spouse benefit is to get that $1,478 a month. If you're paying for home care, assisted living, skilled nursing, and you're not receiving Medicaid in that skilled nursing facility, you can qualify for that $1,478 to help supplement your cost. Other couple quick notes about that VA benefit is that if you do go on Medicaid, when you're on Medicaid in a nursing home, all you get to keep is $50 of your income. You lose that $1,478 from the VA, but the VA says, in turn, we're going to give you $90, and now you get to keep your $90 from the VA plus $50, so you get a bigger personal needs allowance. So it's a benefit there. Sometimes people come to me and they're already applying for Medicaid and someone told them about VA, and we just do a VA application just to get them an extra $90 a month. And then the other component about kind of those VA benefits, if you're not on Medicaid, on nursing home Medicaid, but you're in the assisted living community and you're getting that cash grant benefit I talked about, that's about $342 a month, those two you can pair together. So that can be almost $2,000 a month to help cover the cost of assisted living or skilled nursing that you may not be eligible for Medicaid for some other reason, like you're not a Medicaid bed or too much assets.
And that supplemental nursing care benefit will also reimburse for your drugs. So it can be, I had one client that was getting about $810 a month in regular prescription medication expenses. Guess what? We got the SNC, that supplemental nursing care benefit, and all of a sudden it was a copay of around $1.50 to $2, maybe $3 per prescription. He said, are you serious? I said, yeah, now look at this, you've got almost $2,800 a month coming in that you otherwise would not have had at all if we hadn't told you about the possibility of getting these benefits. It's huge, but again, you gotta go to people that know. And if you don't, especially